Welcome to LexiCast, a podcast designed to help you grow in your legal practice, with weekly updates on current topics, trends, and practical insights. Perfect for listening on the go. Let's dive in.
Welcome to the show, everybody. Today, we are diving into Tranche 2 of the AML CTF reforms and what they mean for the legal profession. For Australian lawyers, this isn't just another routine compliance update, like the shift to e-discovery or electronic filing. It represents a fundamental transformation in how legal practices operate, manage risk, and interact with clients on a day-to-day basis.
And it's happening at the exact same time as another massive shift, right? Because 2026 is also shaping up as the moment generative AI truly matures inside legal practice. So, you've got this double whammy of anti-money laundering obligations and AI ethics arriving simultaneously and reshaping the profession from two completely different directions. But let's start with the AML side. What's the actual legislative headline here?
The headline is the Anti-Money Laundering and Counter-Terrorism Financing Amendment Act 2024. Parliament passed it in November 2024, and it finally closes a regulatory gap that has existed in Australia for more than a decade. Until now, the AML CTF regime has mostly focused on banks, financial institutions, and other traditional reporting entities.
Right. The lawyers and the real estate agents largely sat outside the regime. So, if I'm listening to this while running a practice, what are the hard dates I need to put in my calendar immediately before this catches me off guard?
There are three critical dates to lock in right now. AUSTRAC enrolment opens on the 31st of March, 2026. The obligations themselves officially commence on the 1st of July, 2026. And the final deadline for enrolment is the 29th of July, meaning firms have only a relatively short window to get themselves organised and compliant.
Okay, so from the 31st of March through to the 29th of July, that's the key compliance window. But who actually has to do this? The legislation uses the phrase designated services. And whenever legislation starts using language like that, you know there's complexity hiding underneath it. Who is actually captured by these reforms?
It's essentially any legal service that creates a nexus with the financial system or facilitates the movement or structuring of assets. So that includes assisting clients with property transactions, advising on the purchase or sale of businesses, managing client money, or establishing trusts and corporate structures.
Wait, property matters, commercial transactions, succession planning? That's not some tiny specialist category. That's basically every firm in the country. From a boutique conveyancing practice in Newtown, right through to a top-tier commercial firm in the CBD. If you touch property or business structures, you are probably in scope.
Almost certainly. And compliance here isn't just a matter of ticking a few boxes or filling out a single online form. There are 6 core pillars firms will need to properly implement if they want to meet their obligations under the new regime.
6 pillars. Okay, lay them on me.
First, firms must enrol with AUSTRAC. Second, they need to conduct a firm-wide risk assessment tailored to their clients, services, and geographic exposure. Third, they must establish a written AML CTF program. Fourth, they need to perform customer due diligence, which means verifying client identity before providing designated services. Fifth, they must monitor client activity on an ongoing basis for suspicious conduct. And sixth, they are required to report suspicious matters directly to AUSTRAC.
Hold on, that third pillar, the written program, who actually owns that? Because in a law firm, if everybody owns something, nobody owns it.
Spot on. You have to appoint a named AML CTF compliance officer, a responsible person within the practice whose name literally goes on the door for this.
A named officer. That is a serious shift in liability. And I imagine a lot of firms are going to turn to technology to manage all that customer due diligence and transaction monitoring, right?
Exactly. And that brings us to the second massive shift of 2026, artificial intelligence. Because you're right, firms are adopting identity verification platforms and automated risk scoring systems that use machine learning.
But the ethical rules haven't changed. Your duties under the Australian Solicitors Conduct Rules, competence, independent judgment, confidentiality, those don't disappear just because you bought a fancy software package.
They absolutely don't. The fundamental principle is that AI is a tool, not a delegate. The lawyer signs the document, the lawyer is responsible for what it says.
And the courts are not messing around with this anymore. The New South Wales Supreme Court issued Practice Note SC Gen 23 back in February 2025. Then the Federal Court followed with GPN AI in April 2026. Both of them make it crystal clear you cannot produce an affidavit or an expert report using generative AI without rigorous human verification.
Rigorous human verification, which is necessary because of the four massive risks lawyers face when using AI. Let's break those down. What's the first one?
Hallucinations. Generative AI will just confidently invent citations, non-existent cases, completely fake statutory provisions. And we've already seen these turn up in Australian court proceedings.
Invented case law. And if a lawyer relies on that without verifying it, they haven't delegated their work. They've just added an automated step before their own professional negligence. What's the second risk?
Confidentiality. So, a lot of AI models train themselves on whatever input data you give them. If a solicitor dumps privileged client correspondence into a public tool to summarise it, that is a massive professional conduct breach. You have to know exactly how a system retains data before you use it.
Which leads to the third risk, undisclosed use. The public and regulators are becoming highly intolerant of lawyers using AI without telling anyone, especially when the client is paying for human judgment.
Oh, the public mood on this is so telling. The Governance Institute of Australia did their 2025 Ethics Index, right? Australians rated the importance of ethics at a record high 92. But their perception of actual ethical behaviour was stuck at 43.
A gap between 92 and 43. That is a colossal trust deficit.
It is. And undisclosed AI use just widens that gap. It's a breach of candour. And the fourth risk is systemic bias. AI systems are trained on historical data, which means they reflect historical biases. If you're using an algorithm in family law or employment matters, you might be amplifying systemic inequality.
Which brings us right back to the intersection with AML. Say a firm uses an AI-driven transaction monitoring tool to comply with Tranche 2, and the system flags a client as high risk. Who makes the decision to report that to AUSTRAC?
The lawyer. Always the lawyer. The algorithm can flag it, but the decision to report belongs to the human being with the practicing certificate. AUSTRAC's guidance is totally unambiguous on this. Technology aids judgment. It doesn't replace it.
And that's why 2026 is ultimately a test of leadership. It's not just about compliance. For partners and principals, leadership means treating the AML program as a visible, firm-wide governance instrument, not just a back-office checklist.
I'm publishing a clear AI policy. What tools are approved, what data can go into them. And for junior solicitors, leadership means double-checking that AI summary before it goes into a submission. It means asking the hard questions about client verification.
Because the compliance obligations, AUSTRAC enrolment, court practice notes, that's just the floor. Leadership is what you build above it.
Exactly. The lawyers who treat 2026 as an invitation to be genuine gatekeepers against financial crime and who protect human judgment in the age of AI, they're the ones who are going to define the future of Australian practice.
It's a big moment. Thanks for breaking it down with me. And thanks to everyone for listening. We'll catch you next time. That's it for today's episode on LexiCast. If you're looking for more in-depth episodes that can also be claimed as CPD activities, check out our LexiCast CPD page, linked in this episode's notes. Follow us now to stay up to date, and we'll see you next time.